sense of decorum throughout these proceedings. Any attempt to distract the attention of this court will lead to contempt. Register.
This is a matter with charge number SHC OG 5510-2024 between the state and one Kudolong
May it please my Lord. My name is Dino Melaye S.A. My Lord, my Lord.
to the first defendant, Kodolong. Do you speak and understand the English language? To the second defendant, John Bull. Do you speak and understand the English language?
Yes, I do.
The charges will now be read to you.
Register. Ask him again.
To the second defendant, John Bull. Do you speak and understand the English language?
Yes, I do.
To the first defendant, Kodolong. Do you speak and understand the English language?
Yes, I do.
The charges will now be read to you. Count 1. Statement of offense. Armed robbery contrary to section 1, subsection 2A and B of the Robbery and Firearms Special Provisions Act, LFN 2004. Particulars of offense. Kodolong, John Bull, at and about the evening time on the 20th of November 2023 at number 20 Palview Road, Abeokuta, in the Abeokuta Judicial Division of Ogun State, Nigeria, whilst armed with a gun, did violently rob Ms. Ife Akula of her Nokia 7200 GSM handset valued at 50,000 naira. To the first defendant, Kodolong, do you understand this charge?
Yes, my lord.
How do you plead?
Not guilty.
The first defendant pleads not guilty. To the second defendant, John Bull, do you understand this count?
Yes, I do.
How do you plead?
Not guilty.
The second defendant pleads not guilty. Count 2. Statement of offense. Armed robbery contrary to section 12A and B of the Robbery and Firearms Special Provisions, LFN 2004. Particulars of offense. Kodolong, John Bull, at or about the evening time on the 20th of November 2023 at number 20 Palview Road, Abeokuta, in the Abeokuta Judicial Division of Ogun State, Nigeria, whilst armed with a gun, did violently rob Ms. Ife Akula of her iPad 5, valued at 120,000 naira. To the first defendant, Kodolong, do you understand this count read to you?
Yes, my lord.
How do you plead?
My lord, not guilty.
The first defendant pleads not guilty. To the second defendant, John Bull, do you understand this count read to you?
Yes, I do.
How do you plead?
Not guilty.
The second defendant pleads not guilty. Count 3. Statement of offense. Rape contrary to section 358 of the Criminal Code Laws of Ogun State. Particulars of offense. Kodolong, on the 20th of November 2023, at and about the evening time at number 20 Palview Road, Abeokuta, in the Abeokuta Judicial Division of Ogun State, Nigeria, did commit rape against Ms. Ife Akula by forcefully having sex with her against her consent. So the first defendant, Kodolong, do you understand this count read to you?
Yes, my lord.
How do you plead?
My lord, not guilty.
The first defendant pleads not guilty.
Yes, prosecution counsel.
My lord, pending our application for bail.
He has not moved the application, my lord.
Are you opposing? Do you intend to oppose the application?
In the definite,
Yes or no?
in fact, capital yes, my lord.
Yes. Learned defense counsel.
Which profound and section 36 sub 5 of the 1999 Constitution of the Federal Republic of Nigeria. This motion is also brought pursuant to section 161 sub 2A of the Administration of Criminal Justice Law of Ogun State Federal Court, admitting the first and second defendant to bail pending the termination of this trial. Second of which, my lord, is such further order
Be audible.
or others as this court may deem fit to make in this particular circumstance. My lord, it is also noteworthy that in compliance with the rules of this honorable court, attached to our affidavit, the motion brought before this honorable court, is a 10-paragraph affidavit in respect of the first defendant.
Learned counsel, hold on. Is it a motion or a summons?
The summons, my lord, duly guided. A 10-paragraph of the first and second in respect of the first defendant, a 2-paragraph affidavit in respect of the second defendant, my lord. The first and second defendant on all paragraphs of the affidavit, particularly on paragraphs 6 to 10, which clearly spells out the unfortunate medical conditions of our defendants. My lord, for clarity purpose, accompanying this affidavit is a medical report in respect Witness, are you okay?
God is in session, please. God is in session, please. Yes.
My lord,
Let's proceed.
accompanying the affidavit is an exhibit, a medical report marked as an exhibit 2 and 3 in respect of the first and second defendants respectively. My lord, we have also filed a written address, filed and dated a written address, which we wish to adopt as our oral argument before this court. And we hereby seek the leave of this court to adopt same as our oral argument.
Learned counsel, how many affidavits are in support of this application? In support of this summons?
2 affidavits, my lord.
Leave is granted.
Thank you, my lord. We hereby adopt this written address as our oral application, my lord. My lord, we also seek the leave of the court, my lord, to enumerate on 3 silent issues which we consider very instrumental to our case, my lord.
Leave is granted.
Thank you, my lord.
And you have only 2 minutes to address this court on some salient issues.
Thank you, my lord.
Yes.
My lord, firstly, we cannot forget the sacred right to human liberty. A right enshrined in section 35 sub 4 of the 1999 Constitution. My lord, the defendants, regardless of the accusations levied against them,
The audible, speak to the mic.
the defendants, regardless of the accusations levied against them, my lord, are still entitled to this fundamental freedom. My lord, on the particularly paragraph 7 of the affidavit filed by the prosecution argues that the offense in relation to the second defendant particularly is one of a capital nature.
The prosecution argued in the affidavit.
In the counter affidavit, my
Argued.
lord, he deposed it in the counter affidavit. But however, we the Supreme Court is trite on this rule of law, particularly in the case of Onyebuchi against the Federal Republic of Nigeria, where it held that the court is at discretion to grant bail irrespective the nature of offense, where it considers it so imperative to so do. And so the question before this court I put as an issue is as to whether the nature of the offense in relation to the defendants, the second defendants respectively, my lord, constitutes denying him bail. The Supreme Court is very clear on this position as it answers to the negative. My lord, secondly, we wish to submit before this court and draw the attention of this court, particularly to paragraph 14 of the counter affidavit of the prosecution. The prosecution alleges or deposes in the counter affidavit, my lord, deposited to this court, that the first defendant and the second defendant are not first-time offenders of the crimes they've committed. And they've attached herein a judgment to the affidavit marked as exhibit SIIC to this court. My lord, I wish to draw the attention of this court that herein is the affidavit with no exhibit attached of a judgment. And then this speaks to two issues. One, it further strengthens the presumption of innocence on behalf of the defendants. Secondly, it also reiterates beyond reasonable doubt that the prosecution somewhat intends to allege a crime on behalf of the first and second defendants respectively, to which they have not committed, my lord. My lord, we must be reminded of section 36 sub 5, which presumes innocence on behalf of the first and second defendants respectively. That section, my lord, is not just one to be toyed with, but the cornerstone of our criminal legal system. My lord, in this instant case, the first and second defendants are not convicts, and they are yet to be proven guilty, as stipulated in the case of Olatunji against the Federal Republic of Nigeria. My lord, I humbly urge this court to yield the call of justice in admitting the first and second defendants respectively to bail, pursuant to section 162 of the Administration of Criminal Justice Law of Ondo State, which stipulates clearly
Ondo State?
Ogun State, my lord, sorry, my lord, which stipulates clearly the medical grounds for the admission. My lord, the first and second defendants here before you are not just names on a legal document, my lord. The first defendant respectively is going through the harrowing effect of hepatitis C, and he has hopes, he has dreams, aspirations, and a family anxiously praying for his well-being. We have investigated and paid a cursory visit as well, my lord, to the facility that holds our defendants, and we figured out that the medical facilities were not sufficient to cater for.
Say your submission. What is your submission? Yes.
My lord, my submission is coined from the wise words of Obina JS in the case of Ali against the state, where you opine and I summarily put that as it is only the living that can praise the Lord, so it is only the living that can be tried, convicted, and punished. And my lord, in this instant case, the first and second defendant's life should not be sacrificed on the altar of legal proceedings. I hereby pray this honorable court, my lord, to admit the first and second defendants to bail, pending the determination of this trial, and the affidavits of the prosecution, my lord, should be discountenanced before this honorable court as it pleases this court. May it please this court.
Yes, standing prosecution.
I have never seen a miracle happen like this. The defendant instantaneously started coughing exactly when he raised the issue of health. And my lord,
Hold on. You finally replied to the motion to the summary.
my lord, in defending this self-induced cough and bail application, I want to call on my colleague Dumebi Ima Esquire to please demolish this bail application. Thank you.
I remain my humble self as earlier introduced by my erudite lead counsel, the NLS. My Lord, before I proceed, I would like to state in reply to the counsel on the other side that we duly filed our counter affidavit and attach the exhibits required to the registry of this court. So my Lord, I wonder why counsel on the other side.
Identify the processes required.
The process is dated 8 May. But my Lord, that's not the argument. I just wanted it to be on record. I shall proceed into my legal
It's already on record.
as God pleases. My Lord, before this honorable court this morning is an application for bail by the defendant, and I would like to state that we are vehemently opposing this application. In respect of that opposition, we have filed 2 counter affidavits before this court. The first counter affidavit in respect of the first defendant, dated 8 May 2024, and we shall rely on all paragraphs, particularly paragraphs 2 to 19. And as for the second defendant, also dated 8 May 2024, we rely on all paragraphs, particularly paragraphs 4 to 21. We have also filed our written address in opposition to this application, and we seek the leave of this court to adopt same as our oral agreement.
If it's granted.
As God pleases. We hereby adopt our written address as our oral argument today, and we urge this honorable court to grant all the release contained therein, ultimately dismissing this application for bail from the defendant. However, my Lord, I seek the leave of this honorable court to adumbrate and elucidate on some salient areas that the Constitution would like this honorable court to take into consideration in giving its ruling on this issue.
If it's granted, you have 2 minutes.
As God pleases.
Yes.
My Lord, the offense alleged in this case is one I beg your pardon, of the criminal code laws of Ogun State. And my Lord, as you already know, in your unending fountain of knowledge, and supported by the Latin maxim, "Ave bis legi non est recedendum," my Lord, the words of the statutes should be read in its totality and not in part. The defense rely on section 35 of the 1999 Constitution, which is the force et ergo of our laws. But my Lord, it may be an attempt to mislead this honorable court in citing only subsection 4 of that section. My Lord, if we go down to subsection 7 of that subsection,
Learning Council don't address this court as if you. Yes.
as God pleases. My Lord, can you say that again? I should not address as God pleases. My Lord,
You have a senior advocate with you.
as God pleases. My Lord, it is tribe law that statutes must be read and interpreted as a whole and not in parts. And this is given judicial backing in the case of Tebuno versus State, citation 2008, 1 Nigerian Weekly Law Report, part 1069 at 656, and also the case of Rotimi Amechi versus INEC, 2007, 5 Nigerian Weekly Law Report. And my Lord, the same section that the defense rely on, in subsection 7, I think you of course read subsection 7.
Counsel, the case of Amechi you just cited.
Yes,
Is
ma'am.
it stated in your plea?
No, my Lord, that's why I provided the citation. My Lord, I added this case to my arguments during the night where I was
You are
efficiently.
bringing surprises.
No, my Lord.
The Learning Council today.
Yes,
As God please.
Yes. And you have to seek the leave of this court for you.
to add.
As God please.
Like I said earlier, defense is here to optimize the course of justice. So whatever you take for justice to be said, we do not object to that. So we do have no objection.
Learning Council.
As God please. My Lord, going further and not to waste the time of this honorable court, section 32 sub 3 of the Administration of Criminal Justice and Other Related Matters Law of Ogun State 2017 is also to the effect that where the offense alleged is one of a capital nature, the court is to have the discretion to decide on the issue of bail. Also, my Lord, your Nene brothers at the Court of Appeal, in the case of Bobade, Olutide and others versus Adams, Hamzat, citation provided in our written address, stated that the right to liberty as enshrined in the said section 37 of the Constitution is not an absolute right, especially when there is reasonable suspicion that a capital offense has been committed. And my Lord, it is crystal clear that even the deaf may hear and the blind may see. And we need no soothsayer to tell us that there is compelling evidence that a capital offense has been committed in this case. However, my lord, it is also settled law, and we all know that as to every general rule, there is an exception.
Is this their brief?
Sometimes there is even exceptions to that exception. My lord, the exceptions to the general rule are contained in section 168 and 169 of the Administration of Criminal Justice and Other Related Matters Law of Ogun State 2017. I seek leave of court to read section 168.
So in the knowledge of the court.
As God pleases. My lord, that section provides that it is not only for the defense to assert ill health, but it must also prove by a certification from a medical doctor employed by a government hospital that the ill health is one that cannot be treated by the facilities in the correctional center. And my lord, I put it before the honorable court that the government has fully equipped the correctional centers with top-notch pointed out in our written address. And my lord, it is pertinent for this court to also note that while the defendants were in detention, they never complained of ill health. The detention I'm referring to is one where they were denied police bail up until now where they are being arraigned in court. And my lord, I would like to draw the attention of this court to paragraph 12.
Senior counsel, say your submission.
Yes, my lord. In conclusion, my lord, as I wrap up my argument,
Were they given a time
there are
frame?
other factors that must be considered by this honorable court.
Objection, my lord.
Senior counsel, be on your feet
Thank you,
and
my
say your submission.
Sorry, my lord. The other counsel was on the feet.
Yes, say your submission.
In submission, my lord, the punishment for capital offense is one of death. My lord, any individual who foresees that he may be given this punishment will do anything to gain his freedom. And my lord, considering the fact that if jail bail is granted in this case, the defendant being an ex-convict, my lord, we must take into cognizance his criminal record. And if we also look at the counter affidavit filed before this court, during the course of investigation, he attempted to bribe the police officers. My lord, in your unending fountain of knowledge, taking into consideration these factors that have been brought before your notice before this honorable court, we urge this court that it will be in the interest of justice and in the interest of public safety to remand these defendants in the correctional center, my lord, to prevent such grievous crimes from continually being committed by inhumane individuals pretending to be normal, my lord. Because as they say, many are mad, but few are wrong.
Court is in session.
Hereby promptly submit that the court grants all the release contained in the prosecution counter.
I'm going to defend proceeding to my elected and respected learned friend, O.R. Obeja.
1991 NWLR Part 127, page 486. Justice Omotunde stated, and I will leave a court to read. He said that bail can be granted if the accused person needs to be on regular medical observation, requiring the use of special.
Is this a new argument or
Yes,
is it
my
a
lord.
point of law?
Reply on point of law.
What is the basis of the reply?
That my client needs special
On what basis are you replying?
on ill health, my lord.
Objection, my lord.
Presume you are still learning counsel. Yes, let's hear it. On what basis are you replying?
On ill health. That the defendant began.
Objection, my lord.
Learning counsel, presume you are still.
Thank you, my lord. May I proceed?
On what basis? That's the question.
On point of law, my lord.
What basis?
On the basis of ill health, my lord. Opposed by the prosecution counsel, my lord.
This has been said.
Objection, my lord.
Yes, but there's an
Objection, my lord.
So you cannot go there. Presume you are still. Yes, let's hear it.
My lord, it is very elementary that in replying, you can only talk on gray areas, new issues, and reply on the point of law. She is just repeating medical. I think our new weeks will
Learning
lead
counsel,
to that.
address the court.
Thank you, my lord. I'm just saying that our new weeks will definitely need to learn. Thank you.
Part of the etiquette of the court, Lord, is that the counsel must speak with dignity, must accord dignity to a learned friend. I do not appreciate the fact that the alleged SAN should address my learned friend.
any counsel.
As the court pleases.
Address the court.
Yes, my lord.
Yes.
My lord, I'm saying in a nutshell that the learned SAN, who is not properly dressed in the robe of an SAN, should not refer to my learned friend who is 20 years post score as a new wig. It diminishes her eruditeness.
Please. Learned respective counsel on both sides are hereby ordered to maintain a high sense of decorum and civility.
As the court pleases.
Any further attempt to do otherwise will lead to contempt.
As the court pleases.
Learned counsel for the prosecution. This is a simple question to you. Be on your feet. For the defense, on what basis is your reply on point of law? This is a simple question.
On basis of evidence, my lord.
Resume your seat, learning counsel.
Point of
Resume your seat. This is the ruling of this court. This ruling is based on a summons for bail dated and filed on the 8th day of May 2024 on behalf of the defendant's applicants, who I shall henceforth refer to as the applicant for ease of reference. The application is brought pursuant to Section 35 sub 4 and 36 sub 5 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and under the inherent powers and jurisdiction of this honorable court. The application is praying for the following. 1. In order admitting the defendant's applicants to bail pending the hearing and determination of the trial.
As the court pleases.
And for such further order or orders as this honorable court may deem fit to make in the circumstances of this case. The application is supported by 2 separate affidavits for each applicant. 10 paragraphs affidavit for the first applicant and 14 paragraphs affidavit for the second applicant. The affidavits are dated and filed on the 11th day of May 2024. Accompanying the bail application is a written address dated and filed on the 11th day of May 2024. The learning counsel to the applicants in their written address formulated a sole issue for determination, to wit, whether the applicants are entitled to bail considering their failed state of health and the high possibility of their death before the conclusion of the trial. Arguing the bail application, learning counsel to the applicant submitted with gusto that bail is a basic constitutional right provided under the Constitution. He referred this court to Section 35 sub 4 of the Constitution as amended, and the case of Oyebuchi against Federal Republic of Nigeria, citation before my lords. Learning counsel urged the court to take into consideration the applicant's ill health. He referred this court to Abacha against the state and Ofolu against Federal Republic of Nigeria, citation before my lords, and submitted that all the conditions laid down in the 2 cases to warrant the exercise of the discretion of this court in favor of the applicant coexist in these instances. He urged the court to exercise its discretion judicially and judiciously by granting bail to the applicant. In opposition to the bail application, learning counsel for the prosecution filed 2 separate counter affidavits in opposition to the 2 affidavits filed by the first and second applicant. The affidavits are dated and filed on the 11th day of May 2024. Attached therewith is a written address dated and filed on the same day with the affidavits. The learned prosecution counsel formulated 2 issues for determination, to wit, whether the right to be admitted to bail is an absolute right, and 2, whether the defendants qualify under the grounds to be considered by this court in being admitted to bail. The second issue for determination formulated by the learned prosecution counsel is, in the opinion of this court, inelegantly drafted. For the kind and just determination of this application, the issue for determination is drafted thus: whether the defendant's applicant ought to be granted bail having regard to the nature of the charge against them. On the first issue, learned counsel contended vehemently that by the provision of Section 32, sub 3 of the Administration of Criminal Justice Law of Ogun State 2017, bail in capital offences is only granted in exceptional circumstances. He submitted that in the instant case, the applicant are standing trial on 2 counts charge of armed robbery punishable with death under the provision of Section 1 Sub 2, Paragraph A and B of the Robbery and Firearms Special Provisions Act 2004. Lane Council referred this court to the decision of Court of Appeal in Bobade against Adams Hansa, citation before my lords, where my learned senior brother, Delton West, JCA, entails thus: the right to liberty as enshrined in Section 35 of our Constitution and Article 6 of the African Charter, that nobody shall have his right to liberty taken away, abridged, or violated, is not absolute, especially when there is reasonable suspicion that a capital offense has been committed, as in this instant case. Relying on the above, Lane Council submitted that the right to be admitted to bail is not an absolute right. On the second issue, Lane Council contended that the special circumstances referred to in Section 168 Sub 2, Paragraph A and B of the Administration of Criminal Justice Law of Ogun State and the case of Opolu against Federal Republic of Nigeria, Supra, are nowhere stated in the affidavit deposed to by the applicant, and he therefore urged the court to refuse the application. I have carefully perused the application and the submissions in support thereof. I would like to commend the industry of Lane Council on both sides of the divide for the brilliant and lucid submissions. It has made my job easier as a judge. Now to the main issue. The law, as laid down by the Court of Appeal in Ali against the State, citation before my lords, is that the grant or refusal of an application for bail pending trial must be predicated on whether the alleged or the crime allegedly committed and for which the applicants are standing is of the highest magnitude. A careful perusal of the charge before this court will reveal that the two counts charged for which the applicants are standing trial falls within the purview of capital offense. And the position of law as laid down in replete of judicial authorities, one of which is Abuja against the State, citation before my lords, is that in capital offenses, an applicant seeking for bail must show special or exceptional circumstances to be granted bail. The question now is, what are those special or exceptional circumstances? The provision of Section 168 Sub 1 and 2 of the Administration of Criminal Justice Law of Ogun State 2017 is very instructive on this. It reads, Section 168 Sub 1 provides thus: a suspect arrested, detained, or charged with an offense punishable with death shall only be admitted to bail by a judge of the High Court under exceptional circumstances. Section 168 Sub 2 provides thus: for the purpose of exercise of discretion in subsection 1 of this section, exceptional circumstances include Paragraph A, ill health of the applicant, which shall be confirmed and certified by a qualified medical practitioner employed in a government hospital, provided that the suspect is able to prove that there are no medical facilities to take care of his illness by the authority detaining him. Paragraph B, any other circumstance or circumstances that the judge may in a particular part of the case consider exception. The next most important question is whether any of the special or exceptional circumstances provided for under the above section and the case of Opolu against Federal Republic of Nigeria are sufficiently placed before this court by the applicant in this case. It is my humble opinion that they are not. From the totality of what is before the court, only the second leg of the requirement of Section 168 Sub 2 Paragraph A of the Administration of Criminal Justice Law of Ogun State is deposed to by the applicants in their respective affidavits. It is tried law that in the exercise of discretion against the grant of an application for bail, whether or not the respondent filed a counter affidavit is immaterial, since the consideration is whether in the opinion of the trial judge the applicant have placed sufficient material to persuade him to exercise his discretion in the applicant's favor. Placing reliance on the above, I hold that the applicants have not been able to persuade this court by cogent reason why the discretion of this court should be exercised in their favor. In view of that, the bail application shall be and is hereby dismissed.
We thank you for a well-delivered judgment or ruling, and we ask God to continue to expand your knowledge. And this will definitely help and add to the development of our jurisprudence. I appreciate it.
their health is an issue, so they should be seated with us.
My Lord, I definitely have no problem with this temporary relief.
Yes, you can take your seats. Yes, prosecution.